Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today, we'll be diving into a significant appellate victory for the plaintiffs bar in New York, Wilmington Savings Fund v. Cabadiana. This case underscores the standard a defendant must meet to vacate a default judgment. I'm Adam Friedman, managing partner at Friedman Vartolo, and I'm honored to be joined once again by the legendary Ron Labeck. As many of you know, Ron is one of New York's top default appellate attorneys. Ron, how's it going?
Good. Thanks for the legendary. I'm having T-shirts made.
We should. All right. Glad to have you back so soon. Everyone loved the first one. I'm sure this one will be just as good. So look, before we get into it, can you walk us through the facts of the case? I believe the defendants were defaulted for failure to timely answer or appear.
Yeah, the dates here matter a little bit. We commenced the action in 2019. We weren't released from the foreclosure settlement part until 2021, and we immediately moved for a default judgment, like you said, because the defendant borrowers failed to appear or answer the complaint. We got an order of reference in a default judgment in 2022, and they immediately moved to vacate it based on their claim that they weren't properly served.
Okay.
The lower court granted their application despite finding that their excuse for failing to appear in the action wasn't reasonable. Specifically, they challenged service, and I won't go into the facts too much, but it was shown that their affidavits were blatantly false and that they were in fact properly served. So they really didn't have any other excuse for not appearing in the action. The court, nevertheless, because they found they had a meritorious defense, and what the court said in the interest of justice, vacated their default and allowed them to answer.
Let's just make sure we have this correct. So we're saying the lower court believed that the defendant had not made a showing they were not served.
Yes, and they specifically found that in their order, that because they asked for a traverse hearing on the issue of service, and the court specifically said, you haven't shown the entitlement to such relief because your claims of improper service are invalid.
So in essence, they claimed they weren't served, and the court said, you were served, but since we believe you may have a defense to the action, we're kind of doing away with the rules on governing whether you were served or not, and just letting you late answer.
Yeah, well, what the court did, they said they were vacating the default in the interest of substantial justice, quoting CPLR 3012. It might be D, it might be B, so I'm quoting CPLR 3012, and which says you can vacate default in the interest of substantial justice, but it also says and upon the showing of a reasonable default. So the court kind of, and a lot of courts do ignore the and language in the statute. You can vacate it provided they do show a reasonable excuse for default. And when a court, specifically when a court here finds there is none, it's improper to even look as to whether they have a meritorious defense. The defense here matters too because it was defense based on Bank of America versus Kessler, and we're just after the time when the Second Department found that additional language in an RPA Appeal 1304 notice, any additional language, even that required by federal law, violated the statute and was resulting in dismissal of a lot of actions. And it was before the Court of Appeals overturned that decision. So getting these people into the action with a 1304 defense, it was kind of a new defense and a hot defense, if I dare say that. So the court was more inclined to say, hey, they're raising Kessler, that new case, I'm going to let them back in, even though they really shouldn't.
Forgetting the fact that it was a Kessler defense, is this common? Like, is it common that judges are vacating defaults when they believe that either defendant was served or have no reason to believe they were not?
I'd say it's common enough. I think what a lot of courts do is they'll convolute both standards. So they've got to show a reasonable excuse for the default. Once that's shown, then they have to show a meritorious defense. Courts will kind of look at it like, you're claiming you weren't served, or you're claiming you didn't have notice of the action, right, or you thought someone was defending it for you, or whatever they're claiming. They'll find a more reasonable aspect to that if the defense is in fact meritorious also, which is really not how you're supposed to do it.
Let me ask you a funny question. Let's say the defendant here submitted the exact same motion. However, they removed all claims to not being served, and they said, I think I was served, but I have a meritorious defense. Do you think there's a possibility a lower court would grant a motion like that?
I mean, you'd like to say no, but it's almost what happened here.
Right, because even though they didn't make that argument, the reality is the court said, you were served, but we're vacating on the basis of a meritorious defense.
Right.
I don't know. It's just an interesting point and a way to think about it.
Yeah, and it's contrary to the statute, or at least the court's reading of the statute here, I think.
Okay, so what did the appellate court do?
Well, the appellate court agreed with us, and they overturned the decision based on the fact that no reasonable excuse for the default was found. And then with regard to the meritorious defense, the appellate division confirmed that they're not even going to look at that because they haven't shown a reasonable excuse for their default. And the thing here also is, since they were allowed into this action, they've made 2 motions to dismiss, one which is pending. We have a summary judgment motion pending. We're confident that we're going to win those motions, but we're also confident that those will be appeals and going forward. So this kind of cuts them off at the legs. They're not allowed to appear in the action. It reinstates order of reference. We've already got a referee's report. We can submit an application for a judgment. So it kind of cuts off the last 2 years and possibly more years of litigation here.
Do you believe this decision is going to be used as legal precedent going forward? How helpful is this?
I think it is. I think there's a lot of precedent that says the same thing, but I think this says it bluntly and clearly, and it's a case I'm going to cite in opposing applications like this going forward.
Okay, sounds good. I mean, look, big win. Not surprised. You keep racking them up, hence the legendary status. So great win, seriously, great job. All right, Ron, so you want to recap this for us in 2 sentences or less?
Yeah, I think basically what this case does, it clarifies the law and it makes it clear, despite what we find in some of the lower court decisions, that in order to vacate one's default and appearing in an action, you've got to first show a reasonable excuse for that default, and absent such a finding, it does not matter whether or not they have a meritorious defense, nor can the court exercise its discretion in the interest of justice, absent such a reasonable excuse.
That was great. Not sure if it was 2 sentences.
It was one very long one.
But I think the point was important. Okay. Thank you for joining Ron Labeck and I on the Weekly Friedman, your source for the most essential information in the default industry. As always, if you have any questions or feedback, please feel free to drop a comment below. We look forward to seeing you next time, and thanks for tuning in.